It is perhaps the most persistent myth in all of UK immigration, a whisper that turns into a rumour, that becomes a deeply held belief for so many hopeful people around the world. The idea that having a baby on British soil is a golden ticket, that the act of childbirth in a UK hospital automatically confers not just citizenship upon the child, but a secure, undeniable right for the parent to remain here, to build a new life, to claim their own citizenship. Today, we are going to dismantle that myth piece by piece. But we are also going to build it back up with the truth, which is far more complex, far more challenging, but also holds pathways and possibilities that you need to understand. If you have ever wondered about the real rules surrounding children born in the UK and what it truly means for their parents, then this video is one of the most important you will ever watch. We are going to talk about the child's journey to a British passport and the parent's long and winding road that might or might not lead to settlement. If you are new to this channel, be sure to subscribe and hit the bell icon for upcoming updates on your stay in the UK. Now, let's get started. Let's start with the baby. A child is born in London or Manchester or Cardiff. Is that child automatically a British citizen? The answer, for the vast majority of immigrant families, is a clear and simple no. The UK does not operate on a system of pure jus soli, or right of the soil. Your baby's citizenship is not determined by their place of birth alone, it is determined by the immigration status of the parents at the exact moment the child is born. For a child born in the UK to be automatically British, at least one of their parents must be either a British citizen themselves or have indefinite leave to remain, which is also known as settlement. To make a settlement, if you, as the parent, are here on a skilled worker visa, a student visa, a spouse visa that has not yet led to ILR, or if you are here without a valid visa, your newborn child will not be a British citizen at birth. They will in fact inherit your own immigration status, or lack thereof. They are born in the UK, but they are not born British. Now what if you get your indefinite leave to remain after your child is born? Let's say your child is born in 2025 while you're on a skilled worker visa. Then, in 2027, you finally qualify for and are granted ILR. At that point, because your child was born in the UK and you are now settled, you can apply to register them as a British citizen. It's not automatic. You have to apply using a specific form, the form MN1, and pay a fee, but it is a straightforward entitlement. The key is the parent's status must be secured first. So, we've established the child's situation. Now we turn to the core question, the one that fuels the myth. Does the act of giving birth in the UK grant the parent any automatic right to stay? Can a mother or father walk into the Home Office with their UK-born baby's birth certificate and be granted a visa? The answer is an emphatic, unequivocal no. There is no immigration route for a parent based solely on the fact that they have given birth in the UK. The British government is extremely clear on this point. The birth of a child is not a loophole. It is not a shortcut. The parent's own immigration journey remains entirely separate and must be navigated on its own merits, whether that's through work, family, or another established visa category. If you have no legal basis to be in the UK, having a child here does not create one for you. So, if that's the case, where does this idea come from? Why do so many people believe this is a viable pathway? The truth lies not in an automatic right, but in a long-term, complex and challenging route that is centred on the child's rights and their private life. This is where we move from a hard no to a yes, but. The key you need to understand is the 7-year rule. UK immigration law recognises that as a child lives here, they begin to put down roots. They form attachments, they go to school, they know no other home. The law states that a child who is born in the UK and lives here continuously for the first 7 years of their life can make an application for leave to remain based on their private life. The test the Home Office applies is whether it would be reasonable for that child to leave the UK. For a 7-year-old who has never known another country, who speaks English, has all their friends and schooling here, it is almost always considered unreasonable for them to be uprooted and moved to a country that is entirely foreign to them. Therefore, the child themselves is usually granted leave to remain. And this, right here, is the pivot point. This is where the parent comes back into the picture. If a 7-year-old child is granted the right to live in the UK, they obviously cannot do so alone. They need their parents. So the parent or parents can then make their own application for leave to remain as the primary carers of a child who has a right to be in the UK. This is the indirect route. It is not your right, it is a right that flows from your child. But please hear me very clearly on this next point. This is not a shortcut to indefinite leave to remain. It is the beginning of a very long and restrictive journey. When a parent is granted leave on this basis, they are placed on what is known as the 10-year route to settlement. This means you will be granted a visa for 2.5 years at a time. Every 30 months you will have to apply for an extension, paying the full visa fee and the immigration health surcharge each time. For 10 long years you will live in this cycle of applications, fees and uncertainty. During this entire decade you will almost certainly have the condition of no recourse to public funds attached to your visa, meaning you cannot claim most state benefits. It is a hard road designed to be a concession to human rights, not an easy path to settlement. Meanwhile, your child is on their own, much faster journey. Thanks to recent rule changes, the child who gets leave under the 7-year rule is now on a 5-year path to settlement. So, your child will be eligible for indefinite leave to remain a full 5 years before you are. They will secure their permanent future here while you are still only halfway through your own probationary journey. There is another powerful but often overlooked right that the child has. Separate from the 7-year rule, Section 104 of the British Nationality Act 1981 provides another safety net. It states that a person born in the UK who does not become a British citizen at birth has an entitlement to register as a British citizen if they have lived in the UK for the first 10 years of their life. This is a powerful entitlement. Once your UK-born child turns 10, they can apply to register as a British citizen, regardless of your own immigration status at that time. So let's paint the full picture with a clear timeline. A mother comes to the UK and gives birth. The child is not British. The mother has no visa. For 7 years, they live in the UK. On the child's 7th birthday, they apply for leave to remain and are successful. The mother then applies as the parent and is granted leave on the 10-year route. 2.5 years later, the child is 9.5. The mother has to renew her visa. The child, however, is now on a 5-year route to ILR, so they can apply for settlement at age 12. The mother still has 7.5 years to go. When the child turns 10, they can simply apply to register as a British citizen directly, securing their status completely. The mother, however, must continue renewing her visa until she completes her own 10 years to finally qualify for indefinite leave to remain. As you can see, the reality is a world away from the myth of the golden ticket. It is not a simple transaction of birth for citizenship. It is a complex multi-stage process centered entirely on the rights and welfare of the child, which in turn creates a long, expensive and arduous path for the parent. It is a path born of human rights law, not a path of convenience. So if you are in this situation, or you know someone who is, understand the truth. The birth of a child here is a profound human event, but it is not an immigration strategy. It opens a door, but that door leads to a very long corridor with many more doors to unlock along the way. Your focus must be on the child's milestones, the 7-year mark for their leave and the 10-year mark for their citizenship. These are the anchors around which your own journey will be built. Please remember that this information is for guidance. Immigration law is incredibly complex and your specific circumstances matter. I am not an immigration lawyer, and for official advice you must speak to a regulated professional. Thank you for watching. I know this was a dense and detailed topic, but getting this right is crucial. If this video has helped you understand the reality of the situation, please give it a thumbs up, share it with your communities, and subscribe for more clear, honest breakdowns of UK immigration rules. I'll see you in the next video.